All right, well, welcome everybody. I'm attorney Justin Randall with Hooper Law Office, and we are going to be talking about the top or common estate planning myths that people hear online or hear from friends or family or neighbors or just kind of general public stuff that is really common that we get questions on, but are a lot of times incorrect. A lot of what people read online is obviously incorrect, although that maybe goes without saying these days. Just always something to be aware of. So a couple quick housekeeping items before I get too in depth on anything. This is meant to be an interactive webinar, so if you're you see the Q&A function as part of Zoom, you'll be able to actually ask questions as I go through things. I can see them pop up and answer them. So please, if you have questions related to the topic today, absolutely send those in and I'll see them come up. And then you'll also be at the end of this receiving an email with a couple of materials. So you will have our top 9 estate planning myths on there. And, obviously there's probably overall way more than 9. These are just some of the most common that we run into, and some of which I'll touch on today too. And then there's also a feedback form that you'll receive that will let you reach out to us to set up a time to come in for an initial consultation. If anything we talk about today in particular, if you have concerns about it in your situation or your family, please come in and talk to us. Those are complimentary initial consultations, so they don't cost you anything to come in and talk to us. And we usually schedule them for around 2 hours. Sometimes it takes a little longer depending on the discussions or topics, and sometimes it's not quite as long depending on the issues at hand. So, but if anything we talk about raises those concerns, for you, or you want to have your plan reviewed, please let us know and we can set something up. But okay, so estate planning myths. These, like I said, are common things that we tend to hear. Especially, even when people are coming in talking to us, or, when we give public seminars and people ask questions, a lot of times it's sort of, you hear the same myths a lot. And so I'm going to go through some of the key ones, especially in just sort of general estate planning that come up a lot. Really, the first one is that, somebody will ask, well, does it matter how much money I have or what I own and what the value of that is? Is that going to dictate what type of estate plan I have? Is that going to mean, do I have to have a certain amount of money to have a trust or a revocable trust? Or if I'm under a certain amount of money, does that just mean I should have a will? That kind of question comes up a lot. And it really is way less about the amount or the size of the estate that somebody has, whether or not they're going to use a revocable trust or a will as the basis for their estate plan. What's more important when you're looking at, should I use a will or should I use a trust, a revocable trust in particular, is whether or not probate avoidance is a big goal. So with this is actually another myth that we run into a lot is, oh, I thought if I had a will, I'm not going to go through probate. Well, what wills actually do is they tell the probate court exactly what your wishes are for your estate and who you want in charge of the estate. So if that will is not filed with probate, then there is no guarantee that your wishes will be followed. So wills have to go through probate if you actually want them to be administered. That also means, though, that it doesn't matter if you're talking about somebody with $100 million or, $100,000. If you're looking at, should I go through probate or do I want to go through probate? That's going to dictate more whether or not you're looking at possibly a revocable trust or at a, more of a traditional like will plan for somebody. But the amount of money is way less of a factor. There can be many reasons to go through probate, even, with somebody potentially with, a higher net worth than somebody whose, situation is a little more streamlined and maybe they're just trying to avoid probate. Probate is a very good tool to use. For example, if you have minor children and you have to name guardians for them if you pass away, that has to be done in a will rather than in a trust. It's also, probate is a great tool, for example, if you have what's called a deficit estate, which at that point, obviously the amount you have in net worth matters. because a deficit estate means you owe more than you have in terms of assets. But that's a good reason to use wills to go through probate too, is to make sure that there's a probate happening, that your wishes are still being honored to the extent possible. But if you don't have a lot of creditors, or no debt at all in particular, and whether you have $500,000 in your estate, $1 million, $2 million, that's not relative or not really an important factor in whether or not you use a trust or a will. It's more of how you want the process to be handled after you pass away. So that's way more important. Your family situation is way more important than the amount of money in the estate. If you have, now I mentioned $100 million earlier, if you have that level of assets, we're looking at a whole different kind of trust potentially than like a standard revocable trust, but that's an extreme example. So, but in general, it's within reason, not really a big factor. Okay, so actually I already kind of touched on this, but the second big myth I said is that wills avoid probate, but in particular, there's a lot of bad information out there that a pour over will help you avoid probate. So if you're unfamiliar with that term, a pour over will is the will that somebody would have if their estate plan is using a trust of some kind. Pour over wills basically say that the will, or anything that would go through probate, so again, the will being in probate here, if you had an asset that didn't actually get directed to the trust after you passed away, the pour over will sort of takes that asset in probate and says, we're going to move it back to that trust. That's the beneficiary of my probate estate. So by definition, though, a pour over will then is not helping you avoid probate, because the only place that actually does anything is in probate. So it's very important to know that, if you hear someone say, oh, you should have a pour over will for your trust because that's going to help you avoid probate, it's not going to help you avoid probate, and it is not a replacement for other more important things to do when you have a revocable trust, for example. So that is way more important to make sure that if you have a trust, that you're working with somebody who can help you title the assets properly, or update the beneficiary designations to make sure that they use the trust when you pass away. When you're talking about wills only directing probate assets, trusts also only direct assets that they control. So if they don't own those assets, or if you haven't left the trust as the beneficiary on an account, for example, so that when you pass away, it goes directly to the trust, an empty trust is also not going to direct things. So the coordination of your assets with your estate plan, whether that's a will or a trust, is incredibly important, because it doesn't help you to pay someone to draft this document for you if you're not actually going to use it, right? At that point, what did you create the document for? So it's a really important thing to work with an attorney or a firm that will help you do that. There's a lot of trusts that we review, for example, that maybe somebody had set up 5, 10, 15 years ago, that there's nothing actually titled in the name of that trust. And therefore it's a nice document for them potentially, but it doesn't actually control things. So it's very important to know that pour over will is not a replacement for actually titling things in the trust. Because it will require probate if that's what it needs to use. So just be very careful with that. So that I just keep touching on all these myths that I meant to separate out, but that funding of an estate plan is what I'm referring to when I'm talking about coordinating the assets. So when we talk about funding, what we're talking about is making sure that whatever assets you have actually use the plan. So for example, with a will, if you have all these very important provisions in there, say maybe we have trust set up for minor beneficiaries, or a child with supplemental or special needs that we need to be accounting for and protecting them from like losing any sort of benefits potentially. If you have all of those provisions in your will, that means you want your assets to go through probate, or at least a vast majority of them, depending on if it's like an IRA or not, might be a little different. But your bank accounts, life insurance, real estate, those sorts of things, if you are trying to have those assets protected for somebody because your will has protections for that beneficiary, it's very important to make sure that you actually do use probate for the way your estate will be administered. Otherwise, all of those protections that you have in the will don't do anything. With wills in particular, where this becomes a concern is a lot of times wills give that false sense of security for people thinking, oh, I have it in place, this is what's going to happen. But then they have all of their accounts beneficiary designated directly to those beneficiaries. That can be a really big problem, because that means if there's expenses to be paid and each beneficiary has already received their inheritance through beneficiary designations, that potentially that personal representative or executor, the person in charge of the estate, doesn't have any potential available funds, or if they're also a beneficiary, they have to maybe use their own funds to do that. And then if you had a certain percentage breakdown for the estate, maybe that doesn't actually end up being the end result, because somebody used more of their share to pay expenses than someone else. So if you have a will and you have someone appointed as that personal representative, what you want to do is give that person funds as part of the estate to use to pay expenses, and then only give out the inheritance to the beneficiaries individually after all of those expenses are paid. So that then guarantees that there's no, conflict over, hey, I need money to pay this bill, and somebody refusing to give it back. That can really protect your person you're naming as personal representative too, to make sure that there's no question about them doing things properly or following the right, procedures and all of that. And it's just very helpful for them. Another really important concern that comes up with like beneficiary designations in particular is the fact that a lot of people then, to get around the issue I just mentioned, will say, all right, well, we're just going to leave this one account to that personal representative directly so that they can pay expenses. Well, yes, that then gives them funds to pay expenses, but it also makes them the beneficiary of it, and they own those funds at that time. So if you intended for those funds to be split, there's no guarantee that that will actually happen, because that person is no longer obligated to do so. If you have breakdowns in the estate in your will, you need those assets in order for that to be binding on somebody. You have to have those assets go through probate. Or be very careful in terms of like IRAs, making sure that they match that. And I'm specifically excluding IRAs from, sending them through probate, for example, or 401ks, any of those types of accounts, because that can force a shorter payout for beneficiaries, but non-retirement account assets, that's not a concern. So just be very careful with IRAs and 401ks though, working with your attorney on setting that up properly. So funding the estate is very important. And, the difference between a trust and a will in that sense is, rather than sending things through probate with that trust, you're actually going to potentially title things in the trust during your lifetime, especially depending on the kind of trust you're using. What you put in it may vary. Revocable trust, it's pretty, most of the things that you own, you want in that trust, with a few minor exceptions. Or if it's something that can't be owned by the trust during your lifetime, again, IRAs are a specific example, you can at least name the trust as a beneficiary. So pointing everything through that revocable trust is very important if you want the terms of that to actually work. And it's not just, splitting the assets the right way or making sure expenses are paid. That's not the only reason to make sure that you're actually using a will or a trust if that's your estate plan. A lot of times, and in any trust, for example, or will that I would draft for somebody, it would have provisions that can get triggered in the event that there's unforeseen circumstances that come up in someone's life. So you really want to make sure that if none of us can predict if, for example, there's going to be a medical bankruptcy, or we get sued for some reason, or a divorce or a death in the family, right? Those are sort of the things I'm talking about, where it's nobody can really predict those things. Unless it's, with somebody passing, I suppose, somebody was diagnosed with something potentially, but the rest of that, it's very unknown. So a good will or a good trust will have provisions in there that says, hey, if this beneficiary, has this circumstance happening to them, that we can protect them from that for at least what they're receiving. But if they are the direct beneficiary on an account, they don't get that same protection. So it's very important to just work with your attorney on that to make sure that that's actually what you want to happen and what you want to protect people from, that you provided for in your estate plan, will actually happen. So that's sort of the funding side of things, making sure everything's aligned properly with that. It's something we always help our clients with, and do a lot of times send out the instructions for them, just because it can be complicated, especially if you're unfamiliar with it. So would never expect a client to just go out and know how to do all of that, right? That's why I'm here. Another really big myth in related to estate planning in general, but really more gearing towards kind of long-term care planning, is that gifting the homes, your home or your real estate to the kids is a good idea. A lot of times this comes up it can really come for kind of two key reasons, I suppose. Somebody's trying to transfer it over because they want the kid to have it eventually. And so that's what they're going to do. And they don't want them to have to pay for it. Or they're trying to protect that asset from long-term care expenses. Both of those things are not the ideal way or for both reasons, gifting the home over to the kids is not ideal. For general estate planning, it's not ideal because if you own real estate, your cost basis in that real estate gets adjusted to fair market value if it passes through your estate plan. So if it goes through your will or through your trust, and that's how somebody inherits it, your cost basis, which is essentially, what did you buy the property for, right? So if you bought it for $60,000, but today it's worth $200,000, when you leave that to your kids through your estate plan, that will get adjusted. That $60,000 will get adjusted up to $200,000. That means that if they sell it pretty quickly, there's no taxable gain for them. So that's why it's better to have it pass through their estate. Because if you gift it over, that $60,000 is what they also have. It doesn't get adjusted up. It gets transferred over to them. So then they never get that step up until they pass away, which if they sell it during their lifetime is not super beneficial for them, obviously, because then they'll have to pay a capital gains tax on the gain. So for tax purposes, that's a big reason that it's better to just pass it to them if that's what the real goal is, unless there's a very important reason that they should have it now, which even then it's better than for them to buy it, right? Just for tax purposes, unless there's a reason that can't happen. With long-term care planning, the reason it's not ideal is there's sort of a couple of key things that we run into a lot, concerns we run into a lot when that happens. If you've ever worried about, long-term care planning, you may have heard of the 5-year rule. The 5-year rule is what that means is when somebody's applying for Medicaid benefits while they're in a nursing home or assisted living facility, the application date, they look back 5 years from that date and say, all right, did you gift anything away? Did you transfer things for less than fair market value? That kind of thing. And if you did, there's a penalty that you get for it if it was within the 5 years. So people are often aware of that and try to beat the 5 years, make it out longer than that. So even if that's not a concern though, let's say somebody's made it out 10 years, I've mentioned one of the concerns I would have, which again is the tax implications for it, but upon a sale of the property. But there's two other really big ones too that are big concerns. The first is that when you gift real estate or any asset over to someone else, you no longer own it. So that's where you hear the horror stories of, son started charging mom and dad rent to live in to live in their own home because he had the legal right to do so, or, they evicted mom or dad because they weren't, paying that rent, or for whatever reason they wanted to sell the home, right? So hopefully nobody would do that to you, but it's a highlight of just how that can happen. I mean, they legally have the right to do that. Morally, it's obviously not the right thing to do, but that is legally where they can do that potentially. So even if that's not a concern though, the bigger concern is that whatever happens to the owner of an asset happens to that asset. So what I mean by that is, for liability purposes, if your kids own your home and one of them gets sued or they get divorced or they pass away, that's going to happen to the home that you're living in because they own it, not you. So by gifting it over to them, you've lost the protection that you may have over like your homestead exemptions for things and which, for bankruptcy isn't a huge protection, but it's at least better than what the kids are getting. So you've lost your protection then for that. And it doesn't help you to protect your asset from your long-term care expenses, just to open it up to other people's liabilities. The common example, of course, as well, it's, me and my spouse, and then we have 4 kids. Well, okay, now you just doubled the liability potentially, right? And this can happen where, that's again where those unforeseen circumstances are a concern. There's better ways to protect those assets if that's the issue. A lot of times what we use for that is not a revocable trust, but an irrevocable trust. And that then is not available for the kids' liabilities. There's protections for the original owner of the property, so they can't be evicted by their kids. And it still is a part of their estate plan. So if you're looking at long-term care protection, gifting is not always the best option, and often is not the best option for somebody. If you get advice from an elder law attorney on that to tell you to do that, and that just happens to be the best option, occasionally it may be the way to go. But always talk with an elder law attorney first before you look into that. Because there's a lot of bad advice out there, again, on the internet. So with inheritance, and I mentioned this earlier too, but protecting somebody potentially a child with supplemental needs, where we're looking at maybe there's somebody has a child with autism or Down syndrome or some other sort of supplemental needs that they're receiving assistance, a program for, right, where it's means tested so that they can only have so much and still receive that assistance. So a lot of times I get the question of, does that mean I have to disinherit that child in order for them to maintain that? I don't want to cause them an issue because those benefits are so important to them, right? The benefits are not necessarily just financial, but there's, caretakers potentially that they have access to, educational opportunities, all of those sorts of things. So, it's not just the money aspect of it, but the other sides of things too, that people are trying to not disrupt. And so unfortunately, there's a lot of bad advice out there about, okay, that just means you can't leave them anything. And that's not true. You can't leave them things directly. So if you name them as a beneficiary as an individual on an account, that would be a problem because then it's a countable asset against what they can have. However, if we really want to benefit that child with special needs, what we're looking at doing is having them inherit in a very particular way, in a supplemental or special needs trust. Those trusts are set up so that they're not countable assets against the beneficiary. So that means that they can still receive assistance from you or receive that benefit of inheritance without losing those benefits. And that's the entire reason that those types of trusts exist. And you can do that through your will or through your trust to set that up for an individual. There's also standalone special needs trusts too. So there's a lot of options. If you're somebody who has a child with special needs or is thinking of potentially leaving assets to a child or an individual with special needs, then you can do that in a way that benefits them without the risk of that disrupting their benefits. It's just very important to know how to do that. And that's where, again, an estate planning attorney would come in and help you figure that out. And it's something that we do relatively regularly when that's a concern. So you don't have to disinherit somebody just because they're receiving means tested assistance. And it's not just children with special needs either. I mean, you might be leaving something to somebody who may be in a nursing home and be on means tested Medicaid, right? So there's a lot of reasons that somebody may be concerned about what they're allowed to have. But you can help them out nonetheless just by directing those assets properly. It's just very important not to have them as the direct beneficiary as an individual, like payable on death from an account, because that would be a concern. So definitely just be very cautious about that, but you can absolutely still accomplish what you want to do. It's just doing it the right way. A very, very common question I get for long-term care planning too is, can I gift a certain amount? Is there an amount I'm allowed to transfer without it being counted towards that 5-year, penalty, that or 5-year look back for a penalty calculation? And what people are referring to there is the gift tax exclusion, the amount you're allowed to give without having to file a gift tax return every year, which this year that is $16,000 per person. It went up from 15 from the last couple of years, but that is only for gift tax exclusion purposes or estate tax exclusion purposes. It has absolutely nothing to do with long-term care planning. Medicaid does not care what the IRS says on that exclusion. If it's $1,000 every year, $16,000 or $20,000 every year, if you were doing it as a gift over the 5 years before your application for Medicaid, it's a divestment and there's a penalty associated with that. So very commonly people think they're getting around that 5-year rule by staying within that exemption amount, where all they're really doing is creating that divestment and then just not having to file a gift tax return, which isn't very helpful in the long run for them, because it only matters if you are going over that 16,000 per person per year if you have estate tax concerns, which most of us don't anymore, because you have to have federally over $12 million to actually have a taxable estate. So it's not something that for most of us we have to worry about for estate tax purposes anyway, but it is a concern nonetheless for long-term care planning. So don't gift thinking you're getting around it just because you're staying within that rule. You have to be very cautious. There are better ways to protect assets if that's what you're trying to do. And again, it's good to get advice on that before you engage in any strategy to protect things from long-term care. So just be very, very, very careful on that. I mentioned irrevocable and revocable trusts. A very common question I get is, do revocable trusts protect against long-term care expenses? And unfortunately, they don't protect from availability during lifetime. So they are countable assets for someone in a nursing home if they're applying for Medicaid, revocable trusts, that is. And they are now, if they were done or created after August 1st of 2014, they can be recovered against by Medicaid too after the person has passed away. So they're not protected from those sorts of, nursing home spend down or recovery for Medicaid benefits paid. If a revocable trust was drafted prior to August 1st of 2014, it was still at that point not protected from spend down, calculations, but it was protected from that estate recovery. So those trusts that are older than that are grandfathered in. But again, it's not going to protect you during your lifetime from long-term care expenses. Or spend down for long-term care qualification, right? It's very important to be aware of that. If you're looking to protect things from long-term care expenses and you're trying to use a trust to do that, that's where we're looking at some kind of an irrevocable trust that's specifically designed to protect assets from availability for Medicaid, so that that person doesn't have to spend down through everything. If you're single, you have to spend down to $2,000, right, of available assets, with some exceptions for things you get to keep. But still, it's not a whole lot for that person. And as a single person, you only get $45 a month of income. The rest has to go towards your cost of care. So the big purpose of that irrevocable trust, yes, is to protect from spend down, but also so that whoever that person trusts can use those funds to supplement their care potentially, and supplement things that Medicaid isn't paying for. Like, do they want the private room, or do they want to go out to eat once a week? I mean, that kind of thing. So that's the big purpose of setting money aside, is not to never have to spend it, but to spend it at the rate that actually stretches it out much longer and gives that person a better quality of life. But that would be an irrevocable trust if that's what we're doing in today's planning, environment. One really important thing to be aware of too, for a big myth with long-term care planning, is whether or not life estate deeds protect from long-term care. So life estate deeds, if you're not familiar with that term, which I'm sure many people are not, are specifically designed to transfer some, interest over to the kids, while the parents or the original owners retain a right to reside and still own some portion of the home. And then as that original owner gets older and older, they slowly own less and less of a percentage of that asset. And maybe the kids or whoever those other individuals are own more and more and more. It's based off of life expectancy tables. That was another thing that prior to August 1st of 2014, once the 5 years had passed and all of that, they were protected from availability, and Medicaid could not recover against that property, the real estate, if it was as a part of a life estate deed. However, again, that was another thing that changed in 2014, where any life estate deed drafted post August 1st of 2014 is, if it's past the 5 years, that's still not available during lifetime for the care, but it is recoverable by Medicaid. The interest that person had remaining is recovered by Medicaid potentially. So they are not the best planning strategy anymore, but there are unfortunately still people out there drafting these types of deeds thinking that they are protected. So just be very careful if you've done one of these types of deeds post August 1st of 2014, you may want to have it looked at because there's things you can do going forward to protect it, but you just have to proactively plan. And then I guess running short on time here. So my one last kind of myth that people run into a lot is really that, life insurance proceeds are not subject to like estate taxes. It's true that when you as a beneficiary inherit like a life insurance payout, that is not taxable income to you as a beneficiary, but it is still included in the original, insured's estate in terms of calculations for estate taxes. So if I went out and bought a $13 million life insurance policy, which I don't even want to know what that would cost, but if I had that and I passed away, I would technically have a taxable estate because I'm over the 12 million that I could have. So that estate tax would be subject to about a 45% tax. So it's not something you want to be subject to if you can avoid it. So if you are worried about estate tax planning, don't rely on life insurance policies by themselves to help you avoid any sort of estate tax. There are certain types of trusts that use life insurance as a tool for estate tax planning, but you have to do those things in coordination. It's not by itself a good planning tool, the life insurance by itself. Okay, so I'm a little over time here, and I don't see any questions, but again, just a reminder that you'll receive some of the materials I talked about in an email at the end of this. If you do want to set up an initial consultation, please feel free to reach out to us to do that. It is complimentary. We actually won't be doing one of these next week, but our in-person seminar, Wills versus Trust seminar, is at the Fox Valley Tech Riverside in Oshkosh on April 13th. We do a 2 p.m. and a 6 p.m. session. If you're interested in attending that, please sign up in advance. I believe seating is relatively still limited for that, but if you're interested, sign up for that and let us know that you'd like to attend. Otherwise, I will let you guys enjoy the rest of your day. It seems like, at least when I walked into this room, it was sunny, so I hope it still is. I hope to hear from you guys in the future, and